Thank you very much for your patience. I see it's already 5 minutes past the hour, so we'll just dive in straight into it. Thank you so much for making time. My name is Llyord Mwaniki. I work here at the International Chamber of Commerce, Kenya, as a program manager, and we are very delighted to have you and happy that you were able to make time to join us for this webinar. Before I start and before I introduce our guests this afternoon, or our speakers, I'll be running you through, I'll give you a brief introduction on who ICC is and what exactly we do and how you could participate. First is to run you through the agenda. So agenda for the day, we'll just be having an opening, which we are doing here now. Then we're going to introduce the speakers. Then we'll dive straight into the topic of the day. So just a quick overview on who ICC Kenya is, or the International Chamber of Commerce Kenya. So ICC is the world largest business organization, actually has a membership of over 45 million companies from all over the world, from over 130 countries. And it's actually the only business organization that has a UN observer status. And ICC Kenya is very privileged to be the national committee of the International Chamber of Commerce here in Kenya. We were officially launched in 2017, but now formally registered in 2019. We are currently constituted under we are currently having 3 policy commissions out of the 11 policy commissions that ICC has, and one of them is the Arbitration and ADR Commission. Then the other one is Finance and Banking Commission. Then we have now recently launched the Customs and Trade Facilitation Commission, and soon we'll be launching another one to make them 4 by the end of this year. We are very fortunate and privileged to be hosted here at the Kenya Private Sector Alliance office, and and again supported by a very huge network of experienced people within the KEPSA fraternity, and also benefiting from a wide reach of the private sector here in Kenya. So some of the questions we've been getting lately is how exactly can I participate? How can I join ICC, and how can I be an active member? So usually we do have membership categories. We do have the individual membership category. Again, we've indicated the fee. This has been the most popular because most of our members are usually professionals in various fields. So right now we do have a lot of them being those much more inclined towards arbitration and ADR. Then we do have those who are interested in banking. And recently now, as the message goes out, we're getting a lot of people who are interested in trade and customs, as we have now launched this commission. Actually, we do have our inaugural meeting this Friday morning. So if you'd like to join us, if you're not a member of ICC and you'd like to take part, you'd like to be a member, please do write us an email. We've indicated an email address there, which is info@icckenya.co.ke, or you can actually drop your email on the chat or your phone number, and we'll be happy to reach out to you straight after this meeting and we can have a chat. We thank you again for joining us here. A few more of us are joining. So from this point, I'm just going to invite our speakers so we can dive straight into the subject of the day. So we do have Aleem Visram. Aleem is actually the chair of our Commission on Arbitration and ADR. He is a barrister and a solicitor. He's been qualified in Canada and was admitted as an advocate of the High Court here in Kenya in the year 2009. He attended university in Canada. It's called McGill University, where he completed his undergraduate in political science. He also undertook his law degree at the University of Kent, again, where he graduated with an upper second class honors. And thereafter, he completed his master's degree at Source University in London, where he also graduated with a distinction. So he presently serves on board of several private and public entities. He brings a lot of experience from practice. He practices real estate law, commercial and commercial litigation, arbitration, and mediation. And we are very delighted to have Aleem, of course, as our chair at the Commission on Arbitration and ADR at the ICC Kenya. He also serves as a lecturer at the Strathmore University. Aleem, nice to have you this afternoon and welcome. Our second speaker will be Laura. Laura Lusiji is a senior associate at J. Miles and Company. Laura has been a great supporter of our work here and has been sharing a wealth of knowledge with us. She's an advocate of the High Court of Kenya and a fellow of the Chartered Institute of Arbitrators with over 7 years of experience in international arbitration and ADR work in Kenya and around the world. She has represented clients and sat as Tribunal Secretary in international arbitrations relating to commercial legal disputes under the auspices of LCIA, DFIC, UN CITRO, ad hoc arbitration, and FOSFA international rules. She also offers training on international arbitration. You'll be getting to benefit from the wealth of experience and knowledge that she has in this topic and space this afternoon. She was also recently, she became part of the JMR's team that trained the Ethics and Anti-Corruption Commission here in Kenya on different forms of ADR mechanisms. She has also been called upon to speak on various aspects of domestic and international arbitration at various conferences. Ladies and gentlemen, I introduce to you Aleem and Laura. Aleem, Laura, you can take the floor. Thank you.
Thank you.
Thank you very much, Lloyd, for that introduction. And thank you very much for that overview of the ICC and the work that it does. We have a very exciting presentation and discussion ahead today, which is on the enforcement of foreign arbitral awards, which, as Lloyd said, will be hosted by Laura and myself. Today's presentation or discussion is going to focus really on 5 key thematic areas. And as you will see on the first slide, which Laura is going to load for our benefit.
Right. Yeah.
We are going to be, sorry. We'll just give Laura a second to share the screen. If we can go to the first slide. There we go. Thank you, Laura. So the overview of our discussion today is going to look at 5 key thematic areas. First of all, we're going to ask ourselves, what is enforcement, and talk about that process. And when we talk about what enforcement is, I think from the outset, we're going to say that there's a difference between recognition and there's a difference between enforcement. And we're going to discuss that so that we can all understand what that is. We're then going to look at the overview of the New York Convention, which is probably the most important convention in the world of arbitration and has had the greatest impact on arbitration as a whole. So we'll discuss that and go through it. We are then going to look at the process of recognition and enforcement of foreign arbitral awards under Kenyan law, but also by and large generally. And in particular, we're going to look at some of the barriers to recognition and enforcement under the New York Convention. We're then going to discuss the case law on enforcement of awards. And finally, we will end the discussion with the emerging trends surrounding enforcement. So Laura, over to you. We can move to the next slide.
Thank you. Thank you, Aleem, for the introduction. So just diving straight into the topics that have been highlighted by Aleem, what we're going to first look at is a definition of recognition and enforcement when we're talking about arbitral awards. Recognition is a formal confirmation, generally by a court, of the legal force and effect of an award. And then when we look at enforcement, enforcement is a process that requires registration with a designated court or a specific procedure to compel the party against whom the award was made to carry it out. When you complete an arbitration, there are certain instances, and actually most of the time you will find that the unsuccessful party does not want to comply with the orders given under an award. And so what you would want to do as the successful party is that you would want to enforce those orders against the unsuccessful party, and therefore you would have to go through a process of recognition and enforcement. It is the final step towards completing the arbitration process, although it's a very important step. Normally, you would commence an arbitration, go through the proceedings where you would exchange pleadings and you'd also exchange evidence. You would attend a hearing, of course, if the parties agree to attendance of a hearing. The tribunal would render its award. And then finally, the successful party can enforce the award. However, before that, the unsuccessful party may try to set aside an award. Aleem, do you have any comments with respect to that before we move to the next slide?
Yes, thank you, Laura. So just a few things. When we talk about, as Laura rightly said, when we talk about recognition, we are talking about the acceptance by the court of an award as having been validly made. That, by and large, is the recognition. It's the recognition of that particular award. When we talk about enforcement, as Laura said, we're talking now about a positive action to actually recover the claim and whatever it is that the award has ordered. So when we think about this, we need to think about several other elements. First of all, when does recognition and enforcement arise? And the answer is after the award, right? There is no recognition and enforcement before the award. Logical as that sounds, we have to remember time is important. The second element we might want to think about is in the event of a settlement or a consent award. There may also be recognition and enforcement in the event of a settlement or consent. And as Laura said, by and large, there are issues where a losing party refuses to honor or negotiate the award. And in such scenarios, we may have to seek recognition and enforcement of the award in the event a party has not or is not willing to comply with the award. So what type of awards are we talking about when we think of recognition and enforcement? By and large, we are thinking about foreign, international, domestic, or national awards. But the key issue here being is that because we are talking about recognition and enforcement of foreign awards, that means an award is made in one state, and then you are seeking recognition and enforcement in a different state. So by and large, they may be domestic awards in their state, but they are seeking recognition and enforcement in a different state. The final aspect I'll bring up before we move to the next slide is where are we seeking enforcement? And when we talk about where, international commercial arbitration is very different from litigation, because we may go and seek enforcement either at the seat of that arbitration, or we may also go and seek enforcement where the losing party has assets. And so those are two key areas or two key elements to think about in addition to the timing so far that we've discussed. I think we can move forward to the next slide, Laura.
Sorry. There we go.
Thank you. So let's just have a brief overview of the New York Convention. And as I said, this is the most important convention in international commercial arbitration. So what is the New York Convention? First of all, the New York Convention is a pro-enforcement regime. The idea is that states will become signatories to the New York Conventions, they will ratify it, and then thereafter they will have to comply with the provisions set out in the New York Convention. So what does the New York Convention seek to achieve? It seeks to achieve recognition and enforcement by those states on the same or less burdensome conditions than set out in the convention. What that means is that once you are a state party to the New York Convention, you must comply with the provisions of the convention, and you must recognize and enforce awards either on the same conditions as national awards or on less burdensome conditions. You cannot impose any greater burdens than you would do for your own domestic awards. So that's by and large the rationale behind the convention. And it also sets out very clear criteria or conditions that must be complied with when you want to enforce an award. I won't talk about that now because we're coming to it. But what I will say is that it was entered into force on 7th June 1959, and there are currently 169 signatories to the New York Convention. It is the most successful treaty in the field of international trade law. And the key to this success is the foresight of its drafters in laying down strict conditions for recognizing and enforcing foreign arbitral awards, while leaving contracting states free to apply more liberal rules for recognition and enforcement. Now, when I talk about rules, I'm talking about procedure. So what I'm saying is that the conditions for recognition and enforcement are set out in the New York Convention, but the procedure is left up to the contracting states. And there is a distinction between conditions and procedure. Each state may apply their own relevant procedure, but the conditions have to be harmonized across. So who are some of the African parties to the New York Convention? Botswana, Egypt, Ghana, Kenya, Mauritius, Mozambique, Nigeria, South Africa, and you can see several others. And it's worth taking note that if you look at our Kenyan Arbitration Act, you will see that the conditions of the New York Convention are set out almost verbatim in the Kenyan Arbitration Act of 1995, and especially with regard to Section 36 of our Act. You will also see that the conditions for refusal for recognition and enforcement are exactly the same as set out in the New York Convention word for word. So Kenya has taken on this particular treaty and has actually incorporated it into our own law so that it forms part of our own statute. Some non-African parties, you can see Gambia, Chad, Congo, and several others. Malawi is the latest African country to become a party to the New York Convention, and that happened as recently as 4th March 2021. Any further comments, Laura?
No, I think Aleem has covered that comprehensively. The only comment I would, the only addition that I would have is just to note to the listeners that the New York Convention is not the only convention with respect to enforcement of foreign arbitral awards. As we will see much later in this discussion, there are others like the Icc, the International Convention on Settlement of Investment Disputes. It has its own procedure for enforcement. There's the Riyadh Convention for the Arab countries, OHADA arbitration, and so forth. But as Aleem has said, New York Convention is what is applied by many parties across the board in arbitrations. So moving on to the next slide, we're just going to have an overview of the New York Convention, just look at what it provides for, and then after that, we're going to marry it with the legislation that we have in place here in Kenya and the cases that, the experience we've had in terms of cases, both Aleem and I. Toward the first point, I think Aleem has already explained this. He has talked about the thought process towards the New York Convention, which is that a party is able to enforce an award in a jurisdiction outside of the jurisdiction where the award was made. And to give an example of this, an award can be made in Kenya, but a successful party can take it to Tanzania, being a contracting state of the New York Convention, to enforce that award in Tanzania on the strength of the fact that Tanzania is a contracting state of the New York Convention. And of course, something else that a party will think about when thinking of what countries to enforce an award is where the assets of the unsuccessful party lie. So of course, as a party, you'd have to do due diligence to establish where the assets of the other party are. And this will guide you in knowing which countries you can enforce this particular award. Of course, you'd have to remember that as you go to a particular country, you'd have to think about whether or not that country is a contracting state under the New York Convention. A question that always comes up is, can I enforce an arbitral award in many countries, in several countries? And the answer to that is yes, you can do that at the same time, concurrently. You can enforce in Kenya, Tanzania, South Africa, all at the same time. And of course, you are guided by whether or not this party has assets in these particular countries. There is a famous arbitration case, the UCOS arbitration, which was an arbitration against the government of Russia, where the successful party actually enforced in many countries, Belgium, the US, the UK, India, very many countries. We've also been involved in an arbitration where we have sought enforcement in the US, in the UK, in South Africa, and we were guided by whether or not that particular, where exactly does this party have assets? How do you identify how the party has assets? Of course, you'd have to conduct your own due diligence. You perhaps would have to get an investigator to, try and look at companies, look at property in the land registries in various countries, just to establish whether or not this party has assets in the particular country. The second point is that each contracting state is required to recognize arbitration as binding and enforce them in accordance with the national laws. This point has been discussed by Aleem when we were discussing the previous slide. And when you're taking your award to this country for enforcement, you'd have to take an original award or a certified copy of the same, the arbitration agreement in its original form, and any translations if required. So this is the procedural requirements set out in Article 4 of the New York Convention, and the same is actually mirrored. You will see when we're discussing the Kenyan legislation, the same is mirrored in our Arbitration Act. Aleem?
Thank you, Laura. I think you brought up a very interesting concept there, which is whether or not you can seek enforcement in more than one jurisdiction at the same time. And that's something quite unique to arbitration. There are pros and cons to it. And I think this also has to do with how a particular state sees arbitration in terms of their various attitudes and in terms of how their juridical theory relating to arbitration has been conceptualized. And there are many different juridical theories. Some of them are more territorial, there are more state-based. They focus on what we call the lex arbitrae, but there is a juridical theory known as delocalization, which I think is almost exactly what Laura was talking about. And the notion of delocalization theory is that an arbitration award or arbitration in general is free from the confines of the state. It truly belongs to the parties. And the notion of party autonomy here is taken to the point where this particular process and this arbitration belongs to the parties, doesn't belong to any state, such that an award is not tied to any locality, but may float. It may float and crystallize in the jurisdiction at the point of enforcement. And that really is what delocalization theory is about. So under delocalization theory, you can take that award and you can enforce it in any jurisdiction that you wish, even if that particular award has been set aside in another jurisdiction. So what I'm saying here, and this is quite unique to the French courts in particular, and I'll talk a little bit more about it later when we talk about the different grounds upon which an award may be refused recognition and enforcement. But the idea here is that that award may float in different jurisdictions and may be enforced almost anywhere, even if another jurisdiction has set it aside. And that theory, that delocalization theory, has been put to test in the French courts. There are three key cases really where that has been done. One is called Hill-Martin, the other is called Putrabali, and the other is called Gottrevenken. The citations are foreign and very long, but if you type those out in Google, you'll be able to get the full details of that. And I think going now beyond delocalization theory and coming back to what Laura was talking about, when we talk about the New York Convention, we talk about procedural requirements. It's important to note that the procedural requirements that are on your screen right now are the only procedural requirements, which means that nothing more may be requested or demanded by a state beyond those three elements, which is the duly authenticated original award or certified copy, which is an original agreement or certified copy of it, and translation. Beyond that, a state may not ask for any further conditions from the parties seeking enforcement. And those are very minimal conditions. Now, in terms of procedure, the procedure to actually go about having your award recognized and enforced might be different. But those three conditions are the most that any New York Convention member state may ask for. And that's an important point because there are very few conditions. The other point to make is that Article 3 of the New York Convention speaks in mandatory languages, in a mandatory language. It says each contracting state shall recognize arbitral awards as binding and enforce them. The words are shall. It's very mandatory language. It also goes on to state, there shall not be imposed substantially more onerous conditions or higher fees or even charges for the recognition and enforcement of foreign awards. What that means is that you should not pay more than anyone seeking to enforce a domestic award. And in Kenya, the the fee to enforce a domestic award, according to Rule 9, is actually 10,000 shillings, which means it shouldn't cost you more than 10,000 shillings for recognition and enforcement of a foreign award. I think we can move to the next slide, Laura. So, overview of the New York Convention. Maybe Laura, you can go through this and then I'll comment after, because I have a cases I'd like to add.
Yeah. So here we are looking at what the New York Convention sets out as grounds for refusal of recognition and enforcement of an award. And as we will see later, sorry about that. As we will see later, these same grounds are mirrored in our Arbitration Act. The first one is parties lacking capacity under the law applicable to the arbitration agreement. The arbitration agreement was invalid. You know, different jurisdictions have different criteria for what constitutes an arbitration agreement, but by and large, they are the same. In Kenya, the same is set out in Section 4 of the Arbitration Act. The respondent was not given proper notice of the appointment of the arbitrators or the arbitration proceedings, or the opportunity to present their case. Now, in most arbitration agreements, you will find that there's a procedure laid out for the appointment of an arbitration of the arbitral tribunal. And if the same is not in the arbitration agreement, perhaps the arbitration agreement refers to certain rules that the agreement relies on. For example, the NCIA, the Chartered Institute of Arbitrators arbitration rules, and so forth. And so if that procedure was not properly followed, a party can use that as a ground to ask the court not to recognize and enforce an arbitral award. The award deals with a dispute not submitted to arbitration. Of course, the arbitration agreement will set out the scope in which arbitration may be utilized. And so if it is a matter falling outside of this scope, that is also another ground. The tribunal was not composed in accordance with agreemental laws, which we have already discussed. The award has not yet become binding. This is one of the grounds that another party may use to ask a court to refuse recognition and enforcement. An award needs to have become binding in order for you to take it to a court for recognition and enforcement. And an award becomes binding once the tribunal has given or it has rendered its decision on the particular matter with finality. The subject matter is not capable of settlement, and recognition or enforcement is contrary to public policy. And this is also mirrored in the Kenyan laws. And we also have cases where the courts here in Kenya have refused to recognize and enforce an award because the decision that was rendered by the tribunal, or rather the procedure that the tribunal followed, was against the public policy of Kenya. And we will discuss these cases when we get to the stage where we are discussing the Kenyan legislation with respect to enforcement, recognition and enforcement of awards. Aleem.
Thank you, Laura. So I think this is probably the most important article in the New York Convention. And the reason being is because this is the article that parties use when they want to object to the recognition and enforcement of a particular award. As Laura said, these are the exact same grounds that are found in the Kenyan Act under Section 36. Now, I think one of the most important things to remember when we're talking about grounds for refusal is that the wording of the New York Convention is that recognition and enforcement of an award may be refused. And the words may are extremely important here because the words may have been interpreted as a discretionary capability of the court. And in the case of Dardana Limited versus Yukos Oil, the court said that the words may allow the court to consider other circumstances, such that even if ordinarily an award would be set aside or would be refused recognition and enforcement, those other circumstances allow the court to still allow recognition and enforcement, even if one of those factors exists, which means the existence of a particular factor in Article 5 is not an automatic disqualification or is not an automatic bar to the recognition and enforcement of the award. it merely means that those factors may be considered to refuse recognition and enforcement. So the court may still enforce an award even if one of those factors is present. However, it's important to note that if the structural integrity of the process is fundamentally flawed or unsound, then it will not do so. But the idea is that the New York Convention is a pro-enforcement regime, meaning that we are trying to enforce awards. It is seeking to create harmony in the enforcement of awards, but these areas under Article 5 give guidance and are the grounds, but again, are not an automatic bar. So what are we talking about when we talk about all these different articles? What do we mean when we say that a violation of due process or lack of notice is a ground for refusal for recognition and enforcement? And there are cases here on all of these areas. So when we talk about violation of due process, it might be a situation where a party was not able to submit their case or participate in the process. They did not have the opportunity to conduct or to present their views in entirety. And there's a case there called Kenora versus Guinness, in which one of the parties actually was ill, and his ill health meant that he was not able to present his case. That was actually a ground for refusal for recognition and enforcement on the basis of violation of due process, which is Article 5.1b. What else are we talking about? We're talking about situations where a party, where the award deals with a dispute that has not been submitted to arbitration. So we're talking about jurisdiction here, really. And we have several cases here that might be important. In a case of Tiong Huat Rubber Factory, there was a situation where the excess of authority and issues could not be separated. So it might be at times that you can demarcate excesses of authority from the issues, and you can actually, having demarcated them, set that part of the award aside, but sometimes you can't. And in that particular case, the entire award was set aside. We are also talking about composition of the tribunal, right? So when we talk about the tribunal not being composed in accordance with the agreement of laws, what exactly do we mean at a practical level? Where there's a case called Encyclopedia Universale. And in that case, the chairman was not appointed in accordance with the arbitration agreement. And so the award was not enforced. So even situations like that can become grounds for refusal for recognition and enforcement. When we talk about irregularity in procedure, what kind of procedure are we talking about? One of the most simple and obvious cases could be that the party to that arbitration was not properly a party, or should not have been a party to that arbitration. Here, the famous case of Dalla versus Pakistan comes to mind. The government of Pakistan said they were not a party to this arbitration, should never have been a party. The award was not capable of enforcement against them in the end. When we talk about contrary to public policy, it's important for us to remember that each country has its own public policy, and that public policy plays a part. So in England, there was a case of Soleimani versus Soleimani, where the award, if enforced, would have been contrary to the public policy in England because it would have effected an illegality. The court said that we cannot allow enforcement to effect an illegality, and so they would not allow the award to be enforced, even though on the merits and the contract, on the merits of the particular case and that particular contract was perfectly legal at the place that it had been made, but it would not have been legal in the UK or in England. So I think these are important areas to bear in mind. It's important to look at them and ask yourself, what exactly are we talking about? I think finally, arbitrability is one of the areas there. And I think we have said, if you look at the slide, the subject matter is not capable of settlement, but we mean the subject matter is not capable of settlement by way of arbitration. And when we say it's not capable of settlement by way of arbitration, there are certain areas of law that are not capable of settlement by way of arbitration in particular jurisdictions, and it may vary from jurisdiction to jurisdiction. The most obvious one is usually criminal law. We do not want criminal matters being settled by way of arbitration. That is the purview of the state to determine what it believes should be settled, what it believes requires punitive or penal sanction, as opposed to parties agreeing on what they think is right. Another area might be competition law. And some jurisdictions are now allowing elements of competition law to be arbitrated, but it is still up to the state to determine whether or not they want to allow companies to form monopolies or oligopolies and so forth. So competition law is another area. Arbitrability is a topic in its own, so I won't go too far into it. But that's just to give you a few different examples. When we talk about public policy, finally, I want to say that public policy must be a situation where the award is fundamentally offensive to the jurisdiction's notion of justice. Public policy must also be defined. It must be clear. Our Kenyan case of Christ versus Apollo Nations, which was made many years ago by Justice Ringera at the time, spoke of public policy or contrary to public policy as anything being illegal or contrary to the Constitution, which is a very wide definition of public policy. In the UK, they've taken a different view. They've said that public policy must be clear and defined and dominant. And when we say it's contrary to public policy, we should be able to establish what that public policy is by reference to case law. So some examples there, but I think we can move forward to the next slide.
Thank you, Aleem. So the next slide, we're going to discuss the double exequatur, which is one of the hallmarks of the New York Convention. So before the New York Convention, 1959, there was in place the Geneva Convention on enforcement of foreign arbitral awards. And what took place was that before an award could be enforced in a different state, the party seeking the enforcement had to show that the award had become final in the country where the award was made. What the New York Convention did is that it abolished this requirement. And as we have seen in the previous slide, a ground for refusal of enforcement and recognition of an award is that an award has not yet become binding. So the New York Convention replaced the word final with the word binding. All you have to show is that the award has become binding in order for you to go for recognition and enforcement, which then eases the process of recognition and enforcement of foreign arbitral awards if compared to the previous regime of the Geneva Convention, which made this very difficult. Aleem, I don't know whether you have any point or we should move to the next slide. I'm seeing time is not on our side.
Just a small caveat I'd like to add there.
Yeah.
The New York Convention does apply to binding awards, but it also is applicable only to final awards. And I think it's important to make that distinction or caveat that. What that means is that under the New York Convention, a party cannot seek to have interlocutory awards recognized and enforced unless those awards are disposing of the subject matter entirely, or the issues in that particular arbitration entirely. So the New York Convention still applies to final awards insofar as you are seeking to have final awards recognized and enforced. But there is a difference between what a binding award means is that once an award has been published, it becomes binding. That is the point an award becomes binding. So at that point, once the award is made, it is binding and you may now seek recognition and enforcement of it. That's different from a final award, as I said, because interlocutory awards by and large are not final awards, unless it is a particular interlocutory award that disposes of the issue entirely, such as jurisdiction or something else that might be equally relevant. Also, when we talk about binding awards, one of the criteria under under Article 5 of the New York Convention, which is grounds for refusal, is that an award that has not yet become binding may be set aside. What does that mean when we say that an award that has not yet become binding, and sorry, not set aside, but maybe refused recognition and enforcement? And I think here I might add that an award can be suspended. And once an award is suspended, it is no longer binding. So how does an award get suspended? In the event there is a challenge to a particular award, and that challenge is still pending before the courts may actually suspend the award. In such a scenario, the award is no longer binding. At that point in time, a state may say that this is a ground for refusal for recognition and enforcement of that particular award because it is no longer binding. So just sort of to put some meat and content around those particular terms. We can move to the next slide.
Yeah, thank you, Aleem. Just also to mention, now that you brought up the point, there are instances where a tribunal will issue an award and, cite the award as being a partial award. Sometimes they do this, they have disposed of the issues between the parties, but perhaps they have not rendered a cost award. But this particular partial award, as much as it's written partial award and not final award, going with what Aleem has said, which I agree with, because the tribunal has given its final decision on the particular issue, you can use the award, you can take the award for enforcement, in different jurisdictions on the strength of the fact that the tribunal has rendered its final decision on the particular issue. But of course, you cannot take orders or directions or procedural orders rendered by tribunals for enforcement.
Thanks, Laura. So what are the benefits of the New York Convention in Africa? I think the most obvious one is the increase in direct foreign investment in the continent. And here we have seen that studies now show that ratification of the New York Convention has increased foreign investment by about 10% in the 4 years and around 11% in the last 8 years of ratifying the New York Convention. What that means is because of the harmony in the process. There is a sense of commercial awareness and consistency that in the event you are a member state of the New York Convention, we can have our arbitration award recognized and enforced in accordance with the convention, and we understand how that works, and that promotes foreign investment. I think that's anything further you'd like to add on that, Laura?
No, the only additional point I would say a benefit of the New York Convention is that there's no avoidance of procedural or legal pitfalls that may exist from the country of origin where you want to take your award to be enforced. We have seen that the New York Convention provides the procedure for recognition and enforcement, and this is mirrored by the contracting states, and the New York Convention actually provides that the procedure should not be more onerous than what has already been set out in the convention. And so that standard that has been provided makes it easier for parties in arbitration proceedings to carry out enforcement in countries that have signed into the convention.
Wonderful. I think we can move to the next slide then.
So now we are moving to the section where we want to discuss Kenyan legislation with respect to the process of recognition and enforcement of foreign arbitral awards. This is governed by sections 36 and 37 of the Arbitration Act of Kenya. And as we have said earlier on in the discussion, these two sections mirror the New York Convention, probably even word for word. Section 36 sets out the procedure in which a party should follow when it comes to recognition, and which is producing the original arbitral award or a duly certified copy of the same, the original arbitration agreement or a duly certified copy of the same. And of course, it also mentions translations in the event that the award is not in a language recognized by the courts here in Kenya. I think Aleem also mentioned this earlier, that Rule 9 of the arbitration rules governs the procedure, which really is making your application by way of a chamber summons. You put in an application, perhaps supported by an affidavit, just that is going to produce these documents that the court is going to require. Section 37 is a mirror of Article 5 of the New York Convention, and this sets out the grounds for refusal of recognition and enforcement, and this we have already discussed in detail. The one particular case that I would like to discuss, and then perhaps give Aleem the platform to discuss other cases that he may wish to, is a case where the courts in Kenya refused to recognize and enforce an award because the award was contrary to the public policy here in Kenya. And this is the Tanzania National Roads Agency versus Kunda Singh Construction Limited. Here, the court found that the recognition or enforcement of the award would be contrary to public policy here in Kenya, and that the arbitration award was arrived at in breach of express terms of the agreement between the parties, which provided that the arbitration shall be governed by the laws of Tanzania, and that enforcing such a contract would be contrary to the public policy of Kenya. I think in this case, the courts decided the matter based on English law as opposed to what was set out in the arbitration agreement, which was the law of Tanzania. And as we have already seen under Article 5 of the New York Convention and also Section 37 of the Kenya Arbitration Act, one of the grounds in which a court may refuse recognition and enforcement of an award is if the award was contrary to public policy in Kenya. Aleem has discussed what Kenyan law provides when it comes to the definition of public policy. Aleem, perhaps further cases that you want to discuss with respect to these particular sections of the Kenyan legislation?
So I think this is a good case. The other case I mentioned, and I'll reiterate, is really the primary case under English law, which is Soleimani versus Soleimani. And I'll just reiterate the rationale was that the court would not enforce an award over a contract that is illegal in English law. So the public policy relates to your jurisdiction. And they said that even though the performance of the contract was legal in a different state, under their laws, the performance of that contract would not have been legal. And that was the reason why, according to their public policy, they would not enforce the award. So the key point is this. Given that we are talking about international commercial arbitration, you would need to make sure that you are seeking recognition and enforcement of your award in a jurisdiction where it will be allowed, where it is not contrary to the public policy of that jurisdiction. So you need to be aware of the laws of that particular jurisdiction where you're seeking enforcement. I think that's the main point to be made in terms of public policy. We can move forward to the next slide, perhaps. Laura, you can take this, Icc.
Yes, and I've actually just seen from the chat that someone was asking a question regarding this. So we are moving away from the New York Convention, and we're just going to quickly mention other conventions, other laws with respect to enforcement of foreign arbitral awards outside of the New York Convention. The first one is recognition and enforcement of Icc awards. This is mainly arbitration between investor-state disputes. Awards rendered under the Icc Convention are binding on the parties and shall not be subject to any appeal or to any other remedy. Icc provides a procedure in which awards rendered under Icc should be recognized as if they were final judgments of a court in that particular state. A party seeking recognition or enforcement in a member state under Icc must provide a copy of the award certified by the Secretary General to a competent court or authority which the state has designated for this purpose. Icc itself has no formal role in the recognition and enforcement of an award under the Icc Convention. However, if a party informs Icc of the other party's non-compliance with the award, it is Icc's practice to contact the non-complying party to request for information on the steps that the party will take in order to comply with the award. We also thought that we should mention the Singapore Convention on international settlement agreements resulting from mediation. This is a pretty new convention, and its purpose is facilitation of international trade and promotion of mediation as an alternative form of disputes. The Singapore Convention regulates the enforceability of settlement agreements that resolve commercial disputes of an international nature through mediation. So you cannot really go through the Singapore Convention on matters outside commercial disputes. Say, for example, family matters, you cannot go under the Singapore Convention. But when it comes to commercial matters that have been mediated and a settlement agreement has been generated, then the Singapore Convention becomes useful because you can use it to enforce enforce the agreement of the parties. Kenya is yet to sign this particular convention, but we're seeing some African countries such as Rwanda, Ghana, DRC that have signed, and I'm sure that we are moving to a space where we are also going to sign the same. Aleem, sorry, before I move to the next slide, I don't know whether you have any comments.
No, I think on this area, no comments. Just the point to be made is that mediation is making major headway in the international space. And this particular convention is applicable to mediation, not arbitration. So just for clarity.
Correct, that's also quickly to mention the Hague Convention on Enforcement of Foreign Judgment. Again, this is not applicable to arbitrations, but we thought perhaps we should mention it just to make you aware of its existence. It's also a fairly new convention. And its purpose is to facilitate enforcement of judgments through member states of the particular convention.
Just to comment on the bottom of the slide over there, it says that it does not apply to antitrust and intellectual property matters. I just want to give a little bit of context around that as well. Antitrust and intellectual property matters are also areas that come under that banner of objective arbitrability, or areas that are not typically considered suitable for resolution by way of arbitration. And that's one of the reasons they've been mentioned there as well. And that is also similar to public policy, but different, which we talked about earlier on, which is this matter capable of settlement by way of arbitration, or does it impinge on what typically is a state function and requires state supervision? Criminal law, antitrust, intellectual property, those being some of the areas. So just to sort of caveat those particular elements at the bottom of the slide. We can move forward. Yeah.
Thanks, Aleem. We also thought we should speak to the Africa Continental Free Trade Agreement, which many African countries have become signatories to. The agreement does have a protocol that sets out the procedure for dispute resolution in the event that there's a dispute between two states that have signed to the agreement. So there's a procedure that is laid out, which also allows for parties to arbitrate a dispute. And in the event that an award is rendered, Articles 24 and 25 of the Protocol on Dispute Resolution under this particular agreement does set out the procedure under which a party would seek to enforce any favorable outcome in the event that the other party does not adhere to the recommendations or to the orders that have been given by a particular tribunal. And in this particular agreement, there's a requirement that adherence to a decision of a tribunal or the dispute settlement board is adhered to within 15 months. If the same is not adhered to, then the dispute settlement board established under this particular agreement is going to follow up with the particular state to establish why there's no adherence to the particular decision. So this, the Africa Continental Free Trade Agreement also does set out a procedure for recognition and enforcement of decisions rendered following dispute between two states that are signatories to the particular agreement.
Yeah, just a comment on this. And I think what's particularly important when we talk about other agreements, be they multilateral, be they bilateral, whatever it is. The important element is that the New York Convention at Article 7 is very specific. It says the provisions of this convention will not affect the validity of multilateral or bilateral agreements concerning recognition and enforcement of arbitral awards entered into by contracting states, and will not deprive them any rights they have pursuant to those agreements, especially if those other agreements provide a more favorable regime for enforcement. Now that's the key. That means that if there is a more favorable regime available to you, the New York Convention will not preclude you from using that as your avenue for recognition and enforcement. And there is a case here called Chrome Alloy. And in Chrome Alloy, an award was set aside in Egypt for erroneous application of Egyptian law. But in the US, the award was still enforced. And it was enforced specifically on the grounds that Article 5 of the New York Convention, which sets out the various grounds for refusal for recognition and enforcement, which we talked about, are discretionary. But on the other hand, Article 7 of the New York Convention, which allows you recourse to other multilateral or bilateral agreements, is mandatory. So they said that Article 7 trumps Article 5. If there is a more favorable regime available to you, Article 5 cannot prevent you from recognition and enforcement. You can use another treaty, you can use another agreement to seek enforcement. And that's particularly important, given the latitude that the New York Convention provides you for other avenues of enforcement.
Thanks, Aleem.
Sure, go ahead.
And our final slide on this is the OHADA, the Organization for the Harmonization of Business Law in Africa. This particular organization comprises 17 West and Central Africa countries. They also have their separate regime when it comes to various fields, including arbitration. They have their own arbitration laws, and in their arbitration laws, they do set out a system and procedure for enforcement of decisions by tribunals seated under OHADA. So just as Aleem has said, for this particular organization and these particular countries, they have come up with a system that works for them. Of course, some of these countries are also signatories to the New York Convention, but when it comes to disputes under these particular systems where both parties agree to settle the dispute under the OHADA arbitration laws, the OHADA arbitration laws that do provide for the procedure for enforcement by these particular states. But how, in the event that these particular states contract with a state outside of the OHADA territory, then of course the New York Convention would apply. We have come to the end of our presentation. I think just sharing my final thoughts before I give Aleem an opportunity to share his final thoughts, and perhaps if time allows, we can look at one or two questions. I think enforcement of arbitral awards, while it is the final step of any arbitration proceeding, it's a very important step because you don't want to end up with an award which you cannot enforce. So you just have paper that says that you're a successful party, but you cannot enforce your rights or your client's rights as a lawyer. And so it's important, even at the initial stages of arbitration proceedings, it's important to think about how you can be able to enforce a favorable decision. If you're successful in the arbitration, you could perhaps do some due diligence, find out where does the other side, as a claimant, where does the other side have assets around the world, see where these assets are, they're contracting states of the New York Convention. That way you can also keep an eye on these assets, because sometimes what we have seen is that when a party sees that it's going to be unsuccessful and they're going to get an unfavorable award, then they may dissipate some of these assets, and when you go and search, you will not find them having any assets. So knowing what they have at the onset is going to be good for you in the long run. And in the event that they dissipate the assets, then you can make the required applications in court to note to the court that these particular assets have been. As much as it's a final step in proceeding, it's an important step which you have to have in mind as a party going into arbitration, as a lawyer representing a party in an arbitration. It's good to have it in mind and see what you can do in order to protect your client's interests in the event that you have a favorable outcome. That's it from me, Aleem.
Thank you, Laura. I'm just looking through some of the questions on the chat. I can see that Llyord has responded to questions relating to slides. That's fine. There is a question here, and it's rather a broad question. Is it better for a jurisdiction to have a broad interpretation of public policy or a narrow interpretation? And that's from Oliver Ocheng. I think it's a good question, Oliver, and it's not a difficult. It's not an easy question to answer, because really I think public policy is developed over time and in relation to live issues. And usually it is the issue that dominates the public policy, because that issue has to be ventilated through the courts. So what we do have is we have public policy that covers some key areas which has now been accepted by and large across many nations. And then we have some new emerging areas of public policy. So what are the public policy areas that have been accepted widely? I think one is illegality, right? All jurisdictions have accepted by and large that they will not purport, or they will not allow an illegality to be effected by way of arbitration. So they will not give effect to an award that purports an illegality. Or that seeks to carry out something or affect something that's illegal. I think the other area of public policy that's been accepted by and large is in the area of arbitrability, insofar as by and large most jurisdictions will not allow elements of criminal law to be determined by way of arbitration and the subject of an award. Other areas that have been sort of accepted as part of public policy relate to competition law. And one of the emerging areas that is sort of being interpreted differently is in relation to intellectual property law. So there are many different areas that come to mind when you think of public policy. Illegality, I think, is the main one that everyone sort of agrees on. Should it be wider? Should it be more limited? My personal view is that it would be much better to have a narrow interpretation of public policy so that it is recognizable, so that we understand if something is contrary to public policy. It would be much easier for us, for example, to identify those problems if we have a narrow conception of it. We do know, as I said, that there are areas that every jurisdiction will agree with: fraud, illegality, antitrust, competition law, criminal law. But public policy constantly changes and will continue to change. I know that's not a perfect answer, but I hope it gives you an idea of some of the areas of convergence and divergence. Laura, anything you want to say on public policy?
Yeah, I agree with Aleem, and I think he has mentioned the most common elements where a country would say that this would go against public policy. Just to also mention national interest, which I think comes up in the Apollo versus Christ of All Nations case. But I think that by and large, it would be good to have a limited definition of something that is narrow and someone can point towards when considering public policy. The case that we looked at earlier in the discussion of Tanzania National Roads Agency, when the court rendered its decision, the decision was actually taken for appeal because there was argument with respect to how do you define this as being against public policy, and the same is not noted in the law previously. So I do think that it is helpful to have a narrow definition, interpretation of public policy so that it is clear for parties, litigants, as they move to court.
Great. Yeah, just one thing to caveat. When I talk about illegality, I'm lumping together with illegality, bribery, and corruption. I'm sort of putting that all together. The other one that's just come to my mind as Laura was talking was bankruptcy and insolvency. Again, this is another area that by and large is a matter of public policy. States do not want to leave to arbitral tribunals to determine. There are areas, and I think the way to think of this is there are areas that require state supervision, where there needs to be a clear and definite outcome and that is monitored by the state and directed by the state. Those are by and large areas that tend to be non-arbitrable, but also as a matter of public policy, courts will not give effect to awards touching in those particular areas. I see another question here in relation to whether the New York Convention is applicable to ICSID awards, and I think Laura touched on that. But I think the simple point to make is that the New York Convention relates to recognition and enforcement of an award. What that means is that it does not matter which rules you are carrying out your arbitration pursuant to. You may carry out your arbitration pursuant to any rules, whether they are the Icc rules, as we'd like to promote, and we'd like to say that these are rules that you should consider using for your arbitrations. Many of you will be familiar with the Chartered Institute of Arbitrators rules. Some of you will be familiar with other international rules outside of Kenya, such as the London Court of International Arbitration and so forth. You can use whichever rules you want. Those rules are different from when it comes to the point of recognition and enforcement, because recognition and enforcement is carried out pursuant to the procedure that is relevant in that jurisdiction, which means by and large, there will be an act of parliament, there will be a statute that governs how you carry out recognition and enforcement. The New York Convention says that in the event you're a member state, your statute or your government must not make it any more difficult than it is to carry out recognition and enforcement under the New York Convention. It then says that these are the conditions under the New York Convention. So when you put together your statute, make sure that you have not gone beyond or made it more burdensome or more onerous. So the convention, and the convention is a treaty. The rules apply to your ordinary procedure of the arbitration, but the law becomes important at the point of recognition and enforcement, because every jurisdiction must take account of their own laws when they are actually seeking recognition and enforcement. And that's why even under delocalization theory or whatever theory it is, the second you are seeking recognition and enforcement, the laws of that country then come into effect because the award then crystallizes at that particular jurisdiction. So I think it's important to bear in mind that there's a difference between laws and rules and treaties, and that they all play their part. And you can use whichever rules you want that will not affect recognition and enforcement by and large. I do not see any more questions on the chat, but I think we can, for the next 5 or 10 minutes, because we lost about 10 minutes at the beginning, open up the floor to any further questions. And if anyone has a question, they can raise a hand and we'll be happy to answer them. No questions means that the presentation was clear, that everyone has understood, and will be going out there and becoming a member of the ICC immediately. Can I take that as a definite interest in joining and becoming a member? If there are no questions, I think I will hand back, unless Laura has anything she'd like to add, I'll hand back to Llyord so that he can give his concluding remarks and close up for us.
Yeah, no further comments from me. Thank you, and looking forward to further engagements. Llyord, over to you.
Thank you, Laura. Thank you, Aleem. That was quite insightful. I see we've already gone over about just a few minutes, and thank you so much. That I was learning so much myself on the back end here, and I can see most of the guys online were also doing the same based on the questions that are here. Just to also mention is that we'll be sharing this video shortly. You could find it on our YouTube channel, which is ICC Kenya. If you just Google it there, you will find it. or you can just visit our LinkedIn page and you'll be able to see a link to the video, and there you can follow. In case you have any further questions, do feel free to write to us via email at info@icckenya.co.ke, and we're happy to respond to you. Of course, you can also write to us in case you'd like to become a member of ICC. It's only an annual subscription fee of 5,000 shillings. You can get to participate in these forums. You can get opportunity to be nominated to sit in various commissions. My apologies, I dropped off. I hope you can still hear me.
We can hear you, Lloyd.
All right, my screen went blank. So that's it in a nutshell. If you'd like to join ICC Kenya, please do write to us. We'll be happy to facilitate you and guide you in the process. Also, we do have various programs that we are running in the coming months. So on the 23rd of this month, we do have another webinar. We'll be partnering with the Nairobi Center for International Arbitration, NCIA. And then we can also, in case you'd like to participate in that, look out for information on our channels, that is LinkedIn, and also on email. We'll be sending you an email to that effect. Also, we'll be having a training program later in the year for experienced arbitrators. Again, if you'd like to participate, you'll be seeing further information on that. And also, we'll be having a training program in partnership with CILB coming up in the month on the 21st and 22nd of July. Again, if you'd like to participate, you'll be seeing further information on various channels that will be circulating. So that's a brief update from us. Thank you, Aleem. Thank you, Laura, for making the time and for sharing all your insights. Also, it's important for me to recognize part of our committee members and our deputy chair at the commission, Nikhil Desai, who is on the line. I also saw Mary was on the line at some point. Thank you very much for joining and wishing you a great afternoon. Bye.
Thank you.
Bye.